Uh, Good afternoon, ladies and gentlemen. Welcome to this meeting of the Georges River Local Planning Panel for the 4th of August 2022. My name is Stephen Alchin and I'm the chair of the panel. The panel is currently streaming from the council offices in McMahon Street in Hurstville. The panel members who make up the panel today are Ian Armstrong on my right, Paul Pagotis on my short left, and Jenny Simpson on my far left over there. She is the community representative on the panel, and Paul and Ian are expert members. We're the panel who've been appointed by the Minister for Planning to determine specified development applications, including the development applications that are on the agenda for today, in accordance with the requirements of the Environmental Planning and Assessment Act. The panel acknowledges the traditional custodians of the land on which this meeting is being broadcast as that of the Bidjigal people of the Eora Nation. I'm required to advise you that under the provisions of the Environmental Planning and Assessment Act, this meeting of the panel is being live streamed and will be made available on Council's website. In accordance with the revised meeting protocols during COVID, interested parties wishing to make representations to the panel were requested to register a summary of their interests. 7 registrations were received and forwarded to the panel. The panel has reviewed the registrations and advised the council officers they wish to hear oral submissions from the following persons, who will be called during the course of this meeting in order of the items as published on the council's website. Those speakers are Matthew Allison in respect of the property at 28 Algernon Street, George Kasparis, my apologies, from also in relation to 28 Algernon Street, Oatley, and Michael Vine, also in relation to 28 Algernon Street and Oatley. Phil Armiston, who wants to talk about 977 Forest Road, Lugano, and 3 people wishing to talk about the development proposal for 426 to 428 Princess Highway at Blakehurst. They are Effie Crematis, David Waghorn, and Ross Nettle. The panel has received completed assessment reports from council staff for the 3 development applications. The panel has undertaken an inspection of the sites and nearby locality for the 3 matters on today's agenda. We'll be dealing with each application in order as published on council's website. They are at 20A Algernon Street, Oatley, construction of a dwelling house, swimming pool and driveway. At 977 Forest Road, Lugano, fit out or part of an existing building for a childcare centre. And at 426 to 428 Princess Highway, Blakehurst, demolition works and construction of a residential flat building. As required by the Local Planning Panel Code of Conduct, panel members are required to disclose any conflicts of interest in respect of any matter on the agenda for a panel meeting. The relevant forms as prescribed by the New South Wales Department of Planning and Environment have been completed in a table for council to be included in the online minutes of the meeting. No panel member has disclosed any conflict of interest in any matter on today's agenda. As we progress through the matters on the agenda, only those persons who have registered to speak will verbally be able to make representations to the panel. Each person who has registered to speak is requested to limit their presentation to 3 minutes. I would ask those persons that are invited to speak to the panel via Teams that they speak clearly and in a volume or at a volume that will project into the speakers to assist those viewing the live streaming so they can hear clearly what is being said. To manage the live streaming process, all speakers should leave their camera and microphone turned off until their turn to speak is called. Now, this time I also remind these persons that any defamatory, discriminatory or offensive language used may result in the author being exposed to liability, for which council and the panel take no responsibility. Once we've heard all of the oral submissions on a particular application, we will move on to the next application. Members of the public are free to continue to listen to the broadcast. The determination of the applications will be made in closed session, which is not live streamed or recorded. The determination will be available on council's website once confirmed by the panel, and usually within 2 to 3 days of the meeting being held. I'll now call the first item. This first item concerns a development application for the erection of a house at 28 Algernon Street in Oatley. The first person who is registered to address the panel is Matthew Allison. Are you there, Mr. Allison? Hello, is Matthew Allison? Are you on the call at all? I might move to George Crisparis, and if Mr. Allison is in a position to join the call before we move on to the next item, I'll give him time then. Mr. Crisparis, are you on the call?
Yes, I am, and Matthew is as well. I saw his video just earlier while you were speaking.
Oh, okay. Thank you for that. I'll stick with you for the time being, and then ask Mr. Allison to speak following your presentation.
Okay, great. Should I start?
Yes, please.
Okay, thank you for the opportunity to speak. The same owner who is using Marketech owns both the top and bottom blocks and could have altered lot sizes to accommodate such a design below. Now, instead of impeding their house above, they look to build a second house that sprawls low and long well into the foreshore area below, happily impeding our property and our amenities, not affecting theirs. It's not in the public's interest to approve this property development as it surpasses the FBL and resides directly over where two native gum trees rapidly lost their foliage like a cancer victim loses their hair. These trees turned brown and their trunks cracked like they were burning within. These two trees were at least double-storey in height, and their previous locations are referenced on a survey. These tree locations could also be identified using Council's aerial software near maps visible by the brown canopy using the date palm as a reference. The applicant is an experienced developer, yet the applicant in 2018, without council approval, went ahead and excavated a 35-metre access handle into the rear without permission to gain access, which enabled bulldozers to enter the rear lot in question that led to clearing, land levelling and slope changes. I ask you, is this not pre-development or unauthorised work to enable future development? As the adjoining property owner, this development application will have the following material impacts on our amenity. Unscreened windows that face directly towards and overlook our rear yard, pool area, living room, including our 3-bedroom windows and external entertaining spaces. View impacts. Our view vista to the southwest will be interrupted by a 2-storey building that has regard to the foreshore building line controls and the context of our house and other properties to the east. We believe the loss of views can be equated to very significant. Overshadowing. The property is south-facing and the afternoon sunlight is significant to achieving the light to bedrooms, living areas and open spaces at midwinter. The proposal will obscure the afternoon sunlight and sunsets that are visible from our house in winter. The impacts mentioned will significantly erode the residential amenity, which is intrinsically related to significant departure from the foreshore. We would have no issues with view impacts, overshadowing and possibly privacy if the building was designed to a compliant building line. At the very least, the dwelling could be constructed to the western alignment of our home, which would provide a consistent relationship to the water and an equitable viewing sharing outcome. In summary, we will request that the site undertake an on-site revegetation replacement tree strategy below the FBL to mitigate the loss of native gum trees and to enable local habitat to survive. We request that the mature native gum trees be replaced in the same location as per their survey. Finally, we strongly believe that the building could be designed to fit within a compliant and an available envelope, within the compliant and available envelope. We're not against the construction of this property, subject to the application complying with building line controls. Thank you for your time.
Thank you, Mr. Crisparis. Mr. Allison, I understand you are now on the call. You've got the opportunity to speak now to the panel. Thank you. I think we saw him briefly on the screen, but we've lost him again temporarily, I suspect. Do we know whether Mr. Allison is on the call? I'm struggling to see his name up there.
Hi, George. Hello.
Hello, yes, Steve.
Am I on?
Is that Mr. Allison?
That's right, yes.
Yes, we can't see you, but we can. You're coming through loud and clear. So
Here we go.
I'll turn off my mic and let you have the floor.
Okay. Ready to go?
Yes.
Okay, thanks. My name's Matt Allison. I'm a resident of Oakley and I'm representing Oakley Flora and Fauna Conservation Society, OFF, in the matter of opposing this particular DA at 20A Algernon Street, Oakley. I'm a professional bush regenerator caring for country for the past 32 years. I was a preferred contractor to the former Cogra City Council and currently the Georges River Council. I know just how important it is for biodiversity in our suburbs to have protection for remnant bushland. I've worked for many years at Oakley Point Reserve and in Neverfail Bay Reserve. These areas are protected remnant bushland and they're the bookends of Algernon Street foreshore bushland. Interestingly, in 1997, a biodiversity study discovered that there was still a population of sugar gliders and antechinus residing in Oakley Point Reserve. I've seen them at the other end of the street in 2020. Presumably, they may still exist, but the wanton destruction of remnant native trees and removal of associated habitat-worthy vegetation along Algernon Street foreshore puts them at great risk of species isolation and eventual local extinction. I cannot emphasise enough the critical importance of connectivity of trees where canopies meet to facilitate the unimpeded movement of arboreal native animals from point A to point B. This is why Council declared that this part of the LGA, namely Algernon Street, would be purposely defined as habitat reinforcement area in Council's Green Web map. I guess you're familiar with the before and after aerial photos of the property associated with this DA. The before clearing shows why Council deemed this foreshore area to be so important for native fauna habitat. The connectivity of vegetation protects the native animals that have managed to survive here for thousands of years. Compare the before photo with the after and the contrast screams blatant violation of Council's good intentions to preserve a sliver of nature on a steep block that drops into the Georges River below the foreshore building line. Sydney red gums, or angophoras, are the iconic tree of the Georges River foreshore. With their twisted limbs and pink to orange bark, they are the most recognisable native tree of Oakley. And these trees are now gone. In fact, this damaged vegetation and these missing trees must be replaced to reconnect east to west once again to favour the safe passage of the remaining critically vulnerable native fauna between bush reserves. We all must take a part in protecting endangered species by preserving existing habitat and restoring lost habitat. And this panel should also take this path by rejecting this DA. Thank you very much for your attention.
Thank you, Mr. Allison. The third speaker on this development application is Michael Vine. Are you there, Mr. Vine?
I am. Can you hear me?
Yes, we can. You've got the floor.
Okay. Thank you, panel members. My name's Michael Vine. I'm a town planner and I represent the owner of the property to the east of the development site at 18A Algernon Street. The owner, George, spoke previously. He was the first speaker addressing the panel. And I'm really representing him to identify some of the key planning concerns that we have with this particular application. Firstly, we've read the officer's report and I presume the panel's been provided with all submissions that have been made to the application, one of which was ours. And we generally endorse the recommendations of the report. I think fundamentally it's agreed and pretty widely accepted that this application has been made and a design of a dwelling has occurred on this property without any clear regard to the contextual circumstances and constraints that apply under the planning controls. There's a couple of factors, one of which is the foreshore building line, and the other is the sort of sensitive environmental foreshore area that it seeks to project within. I guess going to the key concerns we have, which is pretty much echoed in the officer's report and accepted by assessment staff, is that the departure from the foreshore building line is significant. It represents a 14-metre departure, and sorry, beg your pardon, a 16-metre departure. And I think the report states that it's a 43%, but I believe for a 30-metre foreshore building line, that's probably close to a 53% departure from the standard, if I'm being technical. And the result of that departure is obviously impacts relating to views, overshadowing, and privacy of our neighbour, of our client's property, is the neighbouring property to the east. Legislatively, the LEP, this foreshore building line control is entrenched in the LEP. It requires a 4.6 to vary it, and council's found that the justification is non-substantive. I agree with council on that, and also in addition, we've got this state environmental planning policy, resilience and hazard, which talks about management of coastal uses area and implores any determining authority to ensure that that a development respects the scale, context, and of the built environment of the foreshore. I guess really our concern is that this site is constrained. It is a smaller site, but it does have an available sort of 200 odd plus square metre envelope, of which any future designer can design within. This dwelling has preference to a pretty generous vehicular access and circulation area, a south-facing courtyard, and a bunch of other sort of inefficient design solutions on an otherwise constrained envelope. And the result of which is a projection significantly forward and a flagrant disregard of the foreshore building line actually being a parameter to the design constraints of this site. I guess from an impact perspective, which is always the most important thing to consider when assessing such a significant departure, the report addresses view impacts on our client site and references those as minor impacts, but it's important to note that any departure from a standard that has resulting view impacts is often accepted to be an unacceptable impact when assessed under tenacity. And I guess, as George touched on before, it's a south-facing property. Western afternoon sun's incredibly important for solar access to this property, of which this particular application will obliterate. And just finally, obviously, the privacy concerns of a projection to this extent in the north-facing windows, it goes beyond what could reasonably be expected in a contextually responsive design. So just in conclusion, and as George said, the owner of who I represent, there's no fundamental objection to the redevelopment of this property for a house, but any such redevelopment should have regard to the applicable planning controls and context and the sensitive foreshore area. So I'd welcome any, I guess, questions the panel may have, and more than happy to answer those.
Thank you, Mr. Vine. Do any members of the panel have any comments or questions?
No, Mr. Chair, not for me. No, Mr. Chair, not for me.
Can I speak now? Okay. I was just reviewing the revegetation plan in the flora and fauna report. I noticed there's a large number of canopy species identified as impacted, but then the vegetation management plan has a substantially disproportionate, inversely proportionate amount of revegetation species list for the canopy flora. So yeah, it's just highlighting there's an improportionate revegetation remediation of the area versus the species that are impacted from the canopy, which is the more significant species. That's like the ankle fruit and the eucalyptus parts of that cliff face and the hillside. Just like to point out that discrepancy between flora impacted versus the revegetation plan.
And through you, Mr. Chair, is it okay if I respond to that?
Yes, briefly, thank you.
Yeah, I obviously any revegetation is welcomed, but fundamentally, as what was spoken before from Matthew, that This foreshore area and the area of which this building will project into forms part of a strategically significant corridor. The introduction of additional trees, more so than what's been removed, is obviously consistent with best practice, absolutely. But you cannot revegetate and re-stabilise that green corridor when there is a two-storey building that projects 16 metres into that foreshore area. So whilst I understand and appreciate that there is an increase in number of trees, the structural and strategic damage on the foreshore will not be sufficiently mitigated by the proposed plantings.
Thank you, Mr. Vine and Mr. Kasparis. They're the three presentations or submissions on that first development application. The next development application is in relation to the proposed childcare centre at Forest Road in Lugano, and Mr. Phil Armisen has registered to address the panel. Mr. Armisen, you've got the floor.
Thank you, Mr. Chairman. As a resident, I fully support Council's refusal recommendation. There are just too many matters still needing attention on this proposal. In my submission to the previous panel, I listed numerous deficiencies in the details of the proposal as presented in Council's assessment report. Because refusal is now recommended, I haven't repeated this list for this meeting, but I understand that information is available to the panel if you wish. For this meeting, I'll just highlight three major concerns for residents. First is the unclear matter of how and when restricted church hours would be approved. Council has said the hours of operation of the church are not a matter for resolution by this DA, yet the plan of management requires limited hours. So if not by this DA, how would these limits on hours be imposed? And given the site is approved as a place of public worship, can the restrictions be imposed? This could be a stumbling block. So I would think it needs to be cleaned up and the process completed before any approval is given to a childcare. The other two major concerns of residents are noise and curbside parking. Basically, the applicant's acoustic and traffic reports are of little value because they take no account of the impacts of overlapping childcare and church activities. My written submission has more detail, but essentially you have before you a proposal for a childcare with no meaningful noise, traffic or parking assessments. Surely that's unacceptable and in itself is sufficient reason for refusal. As a final comment, the reasons Council gives for refusal are not new. They've been reasons for refusal in the past. The fact is, this is a difficult site for a childcare. It's got significant constraints, and by the looks of it, constraints that just cannot be overcome. In 2010, Council first told the applicant the premises were not suitable for a childcare. In my view, the subsequent repeated refusals over 10 years, despite innumerable applicant submissions, are simply confirming the site's unsuitability, just as Council said in 2010. Thank you.
Thank you, Mr. Armisen. There are no other speakers in relation to that development application. So I'll move to the third application, that the proposed residential flat building at 426 to 428 Princes Highway, Blakehurst. The first of our presenters on that application is Effie Crematis. Are you on the call? Thank you.
I am. Thank you for allowing me to speak. I'm not against the development of the neighbouring property into apartments as long as it complies with planning controls. My main concern in this matter is safety, and I think it's vital for everyone's safety that the slip lane is extended to the north to avoid traffic conflict with the Princess Highway traffic near that dangerous bend. I think this is necessary even without further development. I support the council officer's recommendation for refusal and significant changes to the plan submitted, reducing shadow impacts over my property and other effects, more communal space, open space, and a more aesthetically pleasing building. And I just want to thank council for its very thorough assessment of the application. Thank you.
Thank you, Ms. Cremez. The next speaker is David Waghorn. Are you on the call, Mr. Waghorn? We can see your initials on the screen. Are you there?
I am, Mr. Chair. Can you hear me?
Yes, I can. Thank you very much. You've got the
There we
floor.
go. Thank you, Mr. Chair. Just before I start, did you get a dot point summary regarding this project?
Yes, we've got a two-page
Two-page, yep.
document. Yes.
And also a document from traffic TTP?
Correct.
Okay, excellent. Panel members, my name's David Waghorn. I'm from Planning Ingenuity here on behalf of the applicant. Whilst we're disappointed at the recommendation for refusal from council, I think we're more disappointed at the processing and management of this application, and we feel it's really denied us a chance at procedural fairness. In essence, we asked for the panel to defer this matter to allow us to make some changes to the application that are foreshadowed in that dot point summary and that were denied by council. As a background, the DA was lodged in October 2021. In May 2022, the applicant inquired into the status of this application and were told that the planning assessment had not been commenced and that the matter was being reallocated to another planner. So that is 8 months had gone past and no activity with this application or anything was done as far as we know. We expressed our displeasure to the council and within a few days we received a letter that stated that the applicant is to withdraw the application or it will be refused and they were not going to accept amended plans. Whilst we understand that council is of no obligation to accept amended plans, our primary procedural concerns with this application can be summarised in paragraph 26 of the report, which states, and I quote, "There is no possibility for a suitable design option to be realised within the reasonable development assessment timeframe and the application should be withdrawn." I say that this is flawed for two reasons. One, council can surely not know the extent of the changes the applicant was prepared to make if they hadn't engaged with us at all. And two, it is only because of council's actions or 8 months of inactivity that has resulted in the blowout of the development assessment timeframes in the first place. If we had been provided with the referral officer's comments, preliminary assessment concerns or anything from council, the applicant would have had the opportunity to address these concerns and at the very least reduce the outstanding issues. To demonstrate the applicant's willingness to seek a mutually beneficial outcome, we would foreshadow that we would be immediately prepared to offer some design changes, namely, one, the habitable floor space above the height limit for apartment 501 be deleted. Two, the increase to the front setback of level 5 to comply with the front setback requirements. Provide various changes to the design, the facade and the appearance of the building to ensure compatibility with the character of the locality. 4, provide changes to the basement and all levels to improve waste management for the site. 5, improve the landscape character and species selection, especially around the periphery of the site. And 6, to respond to council's concerns in relation to traffic and the development engineers. We accept there may be other changes that council will require, and we'd be very happy to discuss these changes in order to achieve what we say could be a mutually beneficial outcome. We say the changes would more than likely reduce the impacts and improve the design, amenity and compliance, but retain the essence of the residential flat building. So council should not be concerned in this regard. In every other RFB I've been dealing with Georges River Council officers, we've always had the opportunity to discuss the matter with council via an RFI or a request for additional information. So we're having difficulty understanding why this application we were denied the right to discuss anything with council. The cynic in me would say that the timing of the June 2022 letter seems to correlate with council's end of year DA reporting. But the optimist in me would say that given that time has now passed, we should be given the opportunity to make the changes, especially given that the applicant's architect says that we can make these changes probably within a week of getting the deferral from council. In essence, we acknowledge the realities of a recommendation for refusal, but the fact of the matter is that this application is far from an ambit claim. We say that the built form and character is compatible with the area. It is compatible with the higher density development that you see now occurring along Princes Highway, anywhere from Cogra Bay all the way down to Blakehurst. We are of the opinion that there are amendments, including some of the ones I mentioned previously, that could resolve all of the 7 reasons for refusal. So in conclusion, we believe that the development is capable of resolution, but acknowledge that there are a number of issues that are unresolved. We therefore respectfully request that this matter be deferred to enable us to speak with council and resolve these issues to report back to the panel. Panel, thank you for your time. That ends my submission and I'm happy to answer any questions.
Thanks, Mr. Waghorn. Are there any questions or observations, comments from?
Yes, Mr. Chair, I do have some questions for Mr. Waghorn. Mr. Waghorn, your application was submitted on the 7th of October 2021, is that correct?
Correct.
So you're well within the prescribed period under the regulation, which is the 25th of March 2020 to the 25th of March 2022, to appeal to the court on a deemed refusal.
We are.
And why didn't you do
that? Because the applicant would rather not go to court and would rather resolve this with council. As I said, we don't believe we're an ambit claim. We believe we've got a development that is in character with development on the Princes Highway. Yes, I understand now after we get the report that there might be a few changes that are required, but we're happy to make those.
Well, Mr. Waghorn, from what you've just told us this afternoon, it seems that a few changes would translate into some wholesale changes to this proposal, which begs the question as to whether or not you're going to end up with the DA, the same thing that you lodged in the first place. So it's substantially a different proposal.
Mr. Vagotis, I disagree. The essence of the application is still for an RFB. It's still going to be 6 stories. Yes, there's going to be some nip and tuck to it, but I don't think the essence of the application will change. I don't think the amenity impacts will get larger from the application that was originally notified. And if anything, it'll be a better outcome and a lesser outcome.
Thank you, Mr. Chair. Nothing further.
Thank you, Mr. Vagotis. Mr. Armstrong has a question.
Thank you, Mr. Chair. Yeah, I just had one question. So just to clarify, you're saying you lodged the application and you haven't had an opportunity to discuss council's concerns prior to seeing the report currently on this agenda, is that correct?
Correct.
Okay, thank you.
Thanks, Mr. Vagotis. I don't have any questions at this point, so thanks for your time. I'll ask Mr. Nettle if he's on the call to talk to us about the traffic issues.
Thank you, panel.
Thank you, Mr. Chair. I understand that you got my letter of advice assessment. I don't want to therefore read through that verbatim again. The facts are there's an existing vehicle access here. It's going to be improved by providing a separate ingress and egress driveway. As I understand it, the former owner of the property contributed to the construction of the service road. I understand the neighbouring property sought to develop. This property only has a driveway directly onto the highway and was advised to extend the service road. The Transport for New South Wales comment was that it may cause a dip problem, and then goes on to suggest that the driveway moves subtly without realising that that is not where the property extends to. There have been two businesses there for many, many years that attract traffic, purchasing things, and one of those will go as part of this development, and therefore that the traffic generated by that current use would be a discount to the traffic generated by the new development. Neither Transport for New South Wales or Council have put forward any reason or assessment as to why the access arrangement is not supported. The diagrams or the images that I've attached to my letter show how and why the service road commences where it does, and the last diagram shows the turning paths, that there is no impediment to the ingress movement at all, just moves smoothly into the property. So my assessment is that there is no problem or adverse traffic circumstance created by this driveway. Thank you.
Thanks, Mr. Nettle. Are there any questions from the panel members?
That's all right. I'll wait.
Mr. Nettle, having had a site visit today and recognising the speed of traffic that's travelling along the road and that we're basically coming off a bit of a blind corner, given the number of cars that would be parked in this development, do you have any concerns with cars basically backing up, waiting to enter the car park that could be a traffic concern?
No, as I explained, they've moved smoothly and freely into and out of the site. They can pass one another on the driveway. There's no reason for the incoming vehicle to hesitate at all, whereas as things have been for many, many years, with vehicles coming in there looking for a parking spot along the service road for those retail outlets, the situation will be improved.
You just remind me, how many, is it 85 cars we're talking about as part of the development?
Well, it's not parking spaces that generate traffic, it's the number of apartments.
Sure. I suppose the question, you mentioned that there are two existing retail operations in that location. One of them will be retained as part of this, isn't affected by this development. Do you see any issues with conflict between people pulling in to visit the fish and chip place and accessing that development in terms of pedestrians and cars?
No, I don't.
That's all from me.
Mr. Nettle, just following on from what my colleague has put to you, you'd accept, would you not, that there currently is a very small retail shop, which is the bait shop and the fish and chip shop side by side? Now, have you done any calculations as to the type of traffic generation is caused by those two businesses?
No, I just go on my observations. I have lived in the area for years.
Right. Well, unfortunately, so have I. And I can suggest to you that they don't generate a lot of traffic. And I would have thought that it would be plausible to arrive at a conclusion that a residential flat building with how many parking spaces? 85?
I don't have it in front of me at the moment. Sorry.
Well, approximately 85, 70, 80?
I can assist, panel. 82.
82. There'd be no queuing into that driveway at all if the residents decided to either enter the premises or leave the premises in peak hour times. Is that what you're saying to us?
That's correct.
Right. And you say this because of your experience that these types of flat buildings wouldn't generate traffic of any magnitude to warrant any queuing. Is that right?
There's no reason for queuing. The volume of vehicles coming into that service road is not great. There's very, very good sight lines to it. The incoming vehicle into the property comes in before the other parking activities occur, and so I just simply don't see a conflict issue there at all.
Okay, thanks, Mr. Chairman.
Simpson.
Yes, I just got a question about the consideration for parking during construction phase, whether there's any consideration about the local business and residents plus the tradies that will be working with the construction crew in the site.
I haven't given any assessment towards that. I mean, there are properties which have difficulties in sites that are difficult to construct, and you know, any development application will have a consent condition requiring a construction traffic management plan to be prepared and submitted to council for a construction certificate. So that's, you know, the construction traffic management plan would have to be approved by council to allow construction to commence.
Thank you. Just following up on your advice about no queuing, would there be a security car park access which would mean the occupants seeking to access the garage would need to stop, access the security gate opening before the garage door open, before proceeding into the secured building garage?
No, nowhere near the boundary that I know of, be well inside the site.
Thank you.
Mr. Nedler, I had just one question. I think it was at page 2 of your letter, and again just now you've indicated that there are no problems with sight lines. Can you just elaborate on that? Because I was certainly struck when visiting the site this afternoon that there wasn't a whole lot of space before there's both a ridge, the cars coming from the north and rising over a ridge and then descending down towards the relevant property, and the cars travelling the permitted speed in that section is 70 kilometres an hour. So we've got this combination of reasonable speeds, a curve, a ridge. What leads you to think that the sight lines are adequate?
My assessment in that regard is the sight line relevant to the driver egressing the site is well able to see any vehicle approaching from the north entering the service road. I acknowledge that there's a curve in the highway, but it's not a situation where the egressing car is entering the highway. The egressing car is entering and travelling along the service road, and the ingressing car, there's no reason for it to hesitate or slow unduly, as you see in the turning path provided in my letter. That vehicle just moves smoothly into the start of the service road and then directly into the ingress driveway.
Yeah, I suppose I'm certainly wondering just if there's not a lot of space between the front of the property, the service lane, and onto the highway itself. And if for some reason or other traffic or cars or vehicles did have to queue at all in getting onto the site or manoeuvring around cars that are in the service lane, they may be forced to stop in the through lane on the highway, or at least project into it. That's part of my concern about the adequacy of the access and egress arrangements here. Have you got any thoughts on that point?
Well, as I've reiterated previously, this arrangement's been there for many, many years. I'm not aware of any hazards that have been happening there. the activity in the service road in relation to cars coming in there to stop and park will be reduced by the removal of the existing retail activity on the site. And as you see again on that turning path in there, it's just a very smooth movement off the highway into the service road, into the driveway, before getting to anywhere near where the cars park along the service road. So again, I just don't see any problem there.
Okay, thank you for that, Mr. Nettle. That's helpful. I think that's the end of the presentations. So the panel will now close this public segment of the meeting, and we'll move into closed session. Thank you all again for participating and presenting to the panel. As I said earlier on, the panel will make its decisions and they will be published on the council website in the next few days. Thank you.